Hi everyone, and welcome to week 5. Dr. Klein here again as always, and I'm back to discuss from my office this time to discuss the continuation of last week's topic as we got started talking about federal court policymaking. So this week we're going to sort of continue down this pathway, and you had a couple more readings for me on this topic. So 2 chapters from the Howard text, chapter 4 and chapter 5, and then a couple of online readings involving the 2 very similar sort of complementary cases from the Supreme Court this week, the Ferguson versus the City of Charlotte case, and then the Burwell v. Hobby Lobby case. So the Hobby Lobby case at some point should sound a little bit familiar to you since it was the more recent of the 2. So this week I want to spend a little time talking about this topic, but I don't want to get too far in depth because, like always, I want to save a little bit of time for you all to give your presentations on the weekly topic and on the 2 Supreme Court cases. So this week is a little bit different than our previous discussion of federal court policymaking, and a little bit different from the other weeks that we've had so far in class. And this week, more specifically, we're going to sort of turn our attention towards some more current issues that we're facing in the United States at this point. And specifically, we're going to be focusing on the fight for women's rights, the continuous fight that we're facing, and the sort of renewed fight over reproductive rights that we're seeing take place. So clearly, not new battles like a lot of things. They sort of just are renewed in our country. But right now, we're at a pivotal point for both of them. And it sort of seems like in the last at least 4 or 5, maybe a little bit longer years, we've sort of seen this reinvigoration of both of those. And I know that these 2 topics in particular, along with the discussion of same-sex marriage, are rather sensitive for a classroom setting, but I'm not one to shy away from anything. So we're going to make it work, and we're going to be respectful of one another and talk about these topics all the same. All right, so let's start a little bit with chapter 4 of the Howard and Seeger-Walt text. And in this chapter, the authors have really taken the time to discuss what is essentially a short synopsis of the fight for gender equality that we've seen take place over the years. And we sort of come to this sort of like landmark decision or this landmark period of time, and we think of the fight for gender equality as really beginning in 1919 with the passage of the 19th Amendment as sort of this seminal moment for women. But we know that for many years before that point in time, there had to be the fight to even get to 1919 for the passage of the vote for women, right? But despite achieving gender equality in voting, there was really just so much more that needs to be done from that point on, and even from now moving forward, there's still a lot that needs to be done. So your book does a really nice job of highlighting the different court cases that we see that sort of are referring to the legal differences that exist between women and men, and whether or not those legal differences should even exist. So things that today you would have thought would disappear are really still happening in some instances. And what I'm thinking of is sort of this unconstitutional, it's unconstitutional to set a law for these legal differences, but you sometimes still see them happening. Like, for instance, it was ruled unconstitutional that there should be a legal working limit for women and men. But one of the things that we see that pops up is not necessarily this legal limit in terms of hours between the genders anymore, but even a limit on how much leave one gender would receive over the other when a new baby comes into the world, right? So maternity leave is often a little bit longer than paternity leave, and women get not nearly enough time still off, but fathers get even less, right? So there's this thing that's in place where it's a generally accepted rule that men get even less time off to sort of help with the new baby that has come into play. So things like that are still happening, even though they're not necessarily set in stone. It's more company policy that these things are happening. So that sort of refers to the number of hours that one gender has at work over the other. But when we're talking about the older case that talks about the specific review of the number of hours that women were allowed to work compared to men, we saw that it was found unconstitutional because it was really illegal to set limitations on one gender over the other, and there was no reason for it. So this law was something that was reviewed by the court, and it was reviewed on the basis of intermediate scrutiny. And your book does a really nice job of talking about what the difference is between strict and strict scrutiny, intermediate scrutiny, and the rational basis test. And it was overturned because there is really no legitimate state interest in creating a divide between the genders here. There's no reason why women should not be able to work a 40-hour work week just like a man should, right? And the book talks about a few other issues that were overturned on the same basis, right? So drinking age. Both genders should be 21. Overtime pay, restrictions from frontline combat, jury exclusion, and a bunch of other issues that your book gets into. And some of these items were never ever really a consideration for men, right? You never would limit their overtime pay, or you would never exclude them from a jury. But somewhere along the line, someone felt as though women needed to be treated differently. And many of these things have since been overturned, but one of the biggest issues that we're still fighting today is the idea of the wage gap, right? And this is one of the biggest platforms that women are fighting for currently, along with reproductive rights, which we're going to get into in a little bit. But currently, the wage gap is pretty big. It's not as big as it used to be, but it's still pretty big. And the wage gap currently is about 75 to 78 cents for every dollar that men make. That's what a woman can expect to receive. And that's sort of on the high end of the spectrum in terms of the wage gap. And recently we've been seeing more news come out about different industries and how in certain sectors of the workforce women are making even less than that 78 cents to every man's dollar. And this is something that is very real, and it has been happening for quite a while, and I don't necessarily know why it's still continuing, but companies still choose to do this, even though women might be even more qualified than a man for a specific job. She just inherently is paid less. So really, if you're thinking about it, how equal is it if we're doing the same work, or in some instances I might be doing more work than a male counterpart, and I'm only being paid a fraction of my male counterpart's salary? That's just inherently stupid to me and for a lot of other women, but it's still something that is happening, right? And the other issue is that this is happening no matter where we find ourselves working. And I want to bring your attention to this news story that I saw the other day before I was recording this lecture. I saw this on Good Morning America, and I always watch the news while I'm getting ready for work in the mornings. And I was watching Good Morning America, and there was this story, and you might have heard of it recently. It came on the news that the actress Natalie Portman, and you might be saying, okay, Dr. Klein, let's not talk about Hollywood. That's a very different animal. But I think it's relevant here because Natalie Portman came out and was addressing this very issue, and she was promoting some other movie that she's going to be in. But she came out and she said that she has been paid routinely less than her male co-stars, despite having equal billing and being this lead actress in these different films. And one of the films that she had referenced was a movie that she did with Ashton Kutcher called No Strings Attached. And she said while she was filming that movie, she made 3 times less than her male co-star. So I said, okay, well, 3 times less seems like quite a bit. So I went to try and find exactly how much each of those actors made on that movie, but I couldn't find the exact figures. But what this basically is equating to is that women are making 30 cents in Hollywood for every male actor's dollar, right? And that is very low compared to the high-end 78 cents for every dollar that we were talking about before. And I'd love to know exactly how much they're making, because you're sitting here thinking to yourselves probably, they're still making millions of dollars, so I don't really pity her too much. But if you really think about how much she's actually losing compared to her male co-stars, it's quite a bit. And personally, for my own financial gain, I'd love to make 30 cents on every dollar for $1 million paycheck or so, but the principle of it still remains that she should not be making so much less compared to her male co-stars if they're both the lead actor in a movie. If they're both equal co-stars and the principal actors, then she should be making exactly the same as he's making. So it doesn't really make any sense, but it's still showing that no matter what industry you're in, you're still running into this huge pay gap issue. And we're sort of focusing more on women because that's what the chapter is focusing on, but I will acknowledge that just as though women should have equal rights, men should have the same rights that they do as women do in specific areas. So for example, that there was for quite a while a criminal differential in the prosecution of specific crimes, and more specifically I'm thinking about sexual crimes when I'm talking about this example. And if you really think about it, for a long time in the history of sexual crime prosecution, when you look at the legal the formal legal definition of what forcible rape is, it really did not allow for female perpetration or for male victimization. The formal definition of forcible rape for the longest time involved only a male perpetrator and a female victim, right? So if a male was raped, nothing would happen as long as that, nothing would happen because it didn't meet this formal definition of what rape was supposed to be. And the same thing went for statutory rape as well. This was a very gendered type of crime, and the laws specifically stated that. You could only have, the male offender had to be over a certain age and the female victim had to be under a certain age in order for statutory rape laws to apply. So again, the male is always treated as the offender, never the victim, and the female is only treated as the victim and never the perpetrator. So for a long time, males were not able to rape their wives, right, because of this marital law, and domestic abuse was never considered abuse as long as the husband were to beat his wife with something that was not larger than his thumb, right? That's where we get the term rule of thumb from. But there was no vice versa prosecution, right? A wife could never beat her husband, and there would be no prosecution for it. So we sort of see these different these gender differentials pop up in even some of our criminal things. We also saw it in terms of paying. We see it in terms of the gender gap in pay and in criminal prosecution and punishment. We saw it for a long time in terms of land ownership and in terms of who had to pay alimony in a divorce and who was required to pay child support in a divorce, and so on and so forth. But it still takes a long while before there was even a consideration of a proposed amendment to make sure that there was a legal equality set into law between the genders, but it didn't pass, and that's something that I'm going to have you guys talk about in your writing assignment this week. So now really the only true legal protections that are out there for the genders is the EEOC and Title IX. And I want to spend a little time talking about Title IX because it's a very interesting form of legislation, because originally it was set to address the equality between sports teams, right? And if you think about Title IX, if you had a male soccer team, you had to have a female soccer team put in place. And if you had a male football team, but you could not have a female football team, then you had to give the female students an equivalent sport so that everything was equal. But what started out as really a way to have equal protection for extracurricular activities at the college level has sort of manifested itself into this larger form of protection at the college level, and Title IX is now covering campus crimes and mandatory reporting of sexual assault and other types of crime on campus. And this is one of the biggest things that campuses are still struggling with, and we saw it at a large scale level with the Penn State case with Jerry Sandusky, but we're seeing it happen more and more on a smaller scale across college campuses. And in 2014, the Obama administration came up with a report, and they said that over 55 campuses were not in compliance with Title IX requirements in terms of their reporting of different crimes. So it's happening at a pretty large scale level now across different college campuses. So really at this point in my little lecture, I want to sort of just turn towards chapter 5, because I know I'm getting a little bit long here. But in chapter 5 of the text, Howard and Siegelwalt are really taking the time to discuss reproductive rights and the legal safeguards that have been put in place to protect women over the years. And I understand that this is probably a particularly sensitive issue for a lot of you and for people that are not in this class. So I'm not going to take too much time to discuss it, and you guys can hash it out online in your discussion boards. That's really what I want you to do, not me necessarily be talking to you about too much more of it. But I really wanted to take a minute or two to discuss the reasoning behind the court's ruling on the topic of abortion. And really, the background behind Roe v. Wade is often forgotten in the emotional discussion of what abortion protections are doing. And so when we're talking about Roe v. Wade, we're talking about a case that's really has a ruling that rests in the confines of privacy rights. And we have a right to privacy for all things that are sexual and for all things that pertain to our bodies. So sexual partners and preferences, the government does not have a right to step in and say what I can and cannot do in my bedroom. We have a right to privacy within our homes and within our relationships, and specifically when we're talking about relationships, we're talking about marriage. So no one can govern what we do in our homes, provided that that activity is not illegal, right? And no one can gain entry into the privacy of our homes without me giving you consent or without you having a search warrant to come into my property. And our marriages are safe too, right? So I can make an important decision with my spouse or my significant other, and no one has a right to interfere with that relationship dynamic and with the decisions that we make, again, as long as everything that we do decide is illegal and that we are consensual in our relationship with one another. So even though we have all of these different privacy protections, there's not specifically one constitutional amendment that is safeguarding privacy. But the Supreme Court has basically declared that privacy exists between a combination of our First, Third, Fourth, and Fifth Amendment rights. And this privacy then sort of extends to how we govern our own bodies, right? So we have the right to protect and safeguard our bodies. And the government really should not have a say in what I do with my own body. And this argument was once again sort of reinvigorated over the last handful of years between birth control cases and additional cases that the court has reviewed on reproductive rights, and even the right to end our own lives through physician-assisted suicide. So sort of different animals, but all still contributing to this idea of privacy and what I'm allowed to do to my own person. So there is a lot that goes into it, and I'm not discounting the emotional arguments, but from a legal perspective, this is really where the ruling is coming from. So this week in particular, I'm looking for you guys to sort of set that emotional part of it aside and really focus on the legal confines of what the court is ruling in this case. So I told you I wasn't going to spend too much time on the topic, and I'm not going to. But what I do want to see is that you all get involved in a really good discussion this week in particular. And like I said before, I know that these are sensitive topics, and I know that they might seem a little awkward to talk about at first, and sometimes controversial, and you certainly don't want to offend anybody. But as adults in a graduate course, I honestly feel that you should not be afraid to discuss these topics with one another, and that you can still do so while maintaining a certain level of maturity and respect for one another's opinions. So I want you to go ahead and do just that. And I want you to discuss it together, and I want you to discuss it on your own in your weekly writing topics for me. And I want you to, again, watch the video topic presentations and the SCOTUS presentations that your classmates have taken the time and effort to create for you all. And as always, just enjoy the material, right? And I want you to let me know if you have any questions, and if you don't have any questions, Just remember that I'm always available to you should you need me, and if you don't need me, then I will see you guys next week in week 6, and we're going to switch gears a bit and begin discussing the state systems. So have a good week, guys, and I will talk to you all next week. Bye. See you then.